And we're live.
Good afternoon. This is the House Judiciary Committee. It is March the 3rd, 2022. We have 8 bills that we're hearing today. We're going to start with House Bill 1248 from Delegate Valentino Smith. And it is just you. So we will hear from just you and then take questions. So 3 minutes to Delegate Valentino Smith.
Thank you, Mr. Chairman. I know I get points for it being just me. So with respect, I got the rest in writing, though, support. Listen, House Bill 1248 is coming from a joint audit committee binding, and I see the good Vice Chair Delegate Moon on. I don't know if he's like me, but we want to wear a helmet when we're in joint audits because we bang our head on the table about how many repeat findings there are. So this bill stems from the fact that there's been a longstanding and well-documented problem with DHS, the Department of Human Services, and the local DSS child abuse reporting requirements. I'm also the vice chair in appropriations of these budgets. And so now we're putting forth the statute because there's been repeated findings about significant delays in the reporting of child abuse. In the November 20th, 2017 JCH, we were told that SSA did not monitor the timeliness of child abuse and neglect investigations. You can read the rest of the findings in your testimony. In June of 2019, we were once again told that numerous LDSS deficiencies related to critical social service administration policies, including child and adult protective services and the out-of-home placements, again, with not filing their reports and watching them. And finally, this past summer, in June of 2021, we were told that SSA's monitoring processes were not effective for both ensuring timeliness of child abuse and neglect investigations and for the required assessments of substance abuse exposed newborn mothers. And the findings go on in my testimony. So House Bill 1248 will require the local Department of Social Services who fail to conduct an investigation of child abuse or which fail to complete a report in the assigned timeline. The bill has all of the statute written in it, 5706, where we have all the requirements for the various forms of child abuse reports. But now they're going to have to report the delay and the reason to the supervisor, maintain a record of the delay and the reasons for the delay in the child's case file, require the supervisor who receives the report to review and sign the report, and then report to the General Assembly each year on the progress of the child abuse reporting. There is an amendment coming from the department that causes the bill to sunset in 5 years. So there is an amendment so they don't have to keep doing the report. And I'll just finish with, the good Delegate Moon and I in joint audits follow our great auditors and their auditing team. And they told us that we determined that these critical reports were not always accurate, which might have been discovered by SSA and the local departments if active monitoring hadn't been in place. These are our most vulnerable children, or children that don't pick up the phone and text or call us about the abuse they're receiving. This isn't going to solve the problem, but what it at least does is add to our statute a more significant process for the delays, and that we'll get more specific at reporting on the delays. So with that, Mr. Chairman, I'd ask for a favorable report.
Okay, are there questions for Delegate Valentino Smith? Any questions? All right, that was quick. That concludes the testimony for House Bill 1248. Thank you very much, Delegate.
Thank you, Mr. Chairman.
All right, we'll go now to House Bill 1323, and we're going to hear from Delegate Bartlett and Lisa Jordan. 3 minutes for Delegate Bartlett, 2 minutes for Lisa Jordan, and whenever you're ready.
Thank you, Mr. Chair. Sandy Bartlett, Anne Arundel County District 32 for the record. So apparently Judiciary gets one easy bill per year, and this is it. House Bill 1323 is merely a technical correction. There is a reference in the code to a defunct article of the Health General Article 15-127 in the bill. We're just taking it out and we're putting in 11-1007 of the Criminal Procedure Article. We're I'll make sure that, as always, Lisa Jordan will provide the technical or the details as to what 11-1007 does. But essentially, we decided, General Assembly, rightfully so, that victims of sexual abuse would not be charged in situations where, in certain situations. And so there's that's all enumerated. But the thing that you need to remember about this bill is that it is just a corrective measure. It is a technical correction. There's nothing complicated about it. And I urge a favorable vote. This is an easy one, folks. Thank you very much.
What could possibly go wrong now? Let's hear from Lisa Jordan for 2 minutes, please.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault, here in support of House Bill 1323. Thank you to Delegate Bartlett for doing one of the most boring bills of this session. I really had hoped that it would be part of the corrective bill, but alas, my hopes were dashed when DLS declined to do that this year. The Maryland General Assembly moved administration of the reimbursement for sexual assault forensic exams from the health department to the governor's office of crime prevention, youth and victim services. When they did that, they moved the law regarding reimbursement for sexual assault forensic exams from the health general article to the criminal procedure article. And they simply failed to change the cross-reference from health general 15-127 to criminal procedure 11-1007, and the language is exactly the same. So things were moved over, but the cross-reference was not corrected. This corrects the cross-reference. The reason this is coming up is because these are reimbursements for sexual assault forensic exams that are done at hospitals, and our forensic nurses are sometimes running into problems with the hospital billing department, which are, of course, large and complicated, and so they really need to have the cross-reference be corrected. Certainly happy to answer any questions, and again, would urge a favorable report.
Are there any questions for the panel? All right, seeing none, we thank you very much. And that concludes the testimony for House Bill 1323. Moving right along to House Bill 1325. We now have a few more witnesses this time. So we're going to hear from Delegate Williams for 3 minutes, Natasha Kalfani, Shanta Trivetti, Stephanie Glaberson. That's who we'll hear on the first panel. And then we'll go to a panel of one witness who's unfavorable, and my phone will go off. So Delegate Williams, we'll hear from you for 3 minutes, please.
Okay, thank you, Mr. Chair, Vice Chairman, and members of the House Judiciary Committee. I'm Delegate Nicole Williams, testifying today in favor of House Bill 1325, also known as Child in Need of Assistance, Neglect Cases, Marijuana Use. This legislation will just simply change how marijuana use by parents is viewed during Senate proceedings. The use of marijuana by a parent will not serve as a reason enough by itself to separate a child from his or her parent unless there were additional findings proving that the child is indeed in danger. This legislation comes at a time where attitudes towards marijuana use are shifting across our country. Just as in November of last year, 36 states allowed marijuana use for medical purposes. 13 states have decriminalized possession, and 18 other states have legalized recreational use for adults. Here in Maryland, we have been having a robust conversation about the legalization of recreational use for adults. In fact, the possession of small amounts has currently been decriminalized in our states, and in the process of developing a system for full legalization. So as we continue to have the conversation and pass legislation out of the House to move towards full legalization, we should also have a conversation about the impact that marijuana use plays in a child in need of assistance cases. These lingering restrictions regarding marijuana possession and use have had, in the words of the American Medical Association, disproportionately and adversely impact marginalized and minority communities. And it's no secret that Black individuals face more severe repercussions for marijuana use, possession, and usage when compared with others. This applies in all legal proceedings as well as in Senate cases where those handling neglect cases where marijuana is involved often causes irrevocable damage to the structure of the family. Marijuana use alone is not sufficient enough of an indicator for how well an individual can parent a child, and using it as a basis for family separation only causes further trauma and anxiety for both the parent and the child. And so this legislation will help change the culture, which is long overdue. And for these reasons, I urge the committee to give a favorable report to House Bill 1325.
Okay, let's hear now from Natasha Kalfani, please, for 2 minutes.
Good afternoon, Mr. Chair, Vice Chair, and members of the committee. My name is Natasha Kalfany. I'm an attorney at the Office of the Public Defender. I represent parents whose children have come before the court for allegations of abuse or neglect. I'm testifying today in support of HB 1325, and I would like to share an experience of a client whose marijuana use unnecessarily and unfairly prevented her from reunifying with her children. My client is Ms. B, a single mother of 6. To financially support all of her children, Ms. B would at times leave the older children to care for the younger while she would go to work. Consequently, she came to the attention of the Department of Social Services due to a lack of appropriate supervision. She would eventually lose custody of her children. The younger 3 children were placed in the custody of their father. The older children were placed in foster care. During the department's investigation, it was learned that Ms. B smoked marijuana. There were no allegations she smoked in front of her children or that her marijuana use negatively impacted her parenting. Nevertheless, Ms. B was required to complete drug treatment in addition to other services. Ms. B had improved her situation and was ready to receive her children. Ms. B would eventually successfully complete services except for drug treatment. All 3 children were now preteen and teenaged, desperately wanted to return to her care, and 2 of the 3 were declining in every way in the foster care system. Unfortunately, Ms. B continued to test positive for marijuana, even though she was in treatment. And as a result, her children were forced to languish in care. Ms. B would eventually get 2 of the 3 of her children returned, the 3rd opting to go with her father. This bill would have allowed Ms. B to reunify with all 3 of her children, rescuing them from the months and even years of the devastating impact that continuing in foster care caused them. Unfortunately, Ms. B's story is not unique, and for this reason, I urge you to submit a favorable report for HB 1325. Thank you.
Thank you very much. We'll hear now from Shanta Trivedi, please.
Good afternoon, Mr. Chairman, Mr. Vice Chair, committee members. My name is Shanta Trivedi. I'm an assistant professor of law and faculty director of the Sarah and Neil Meyerhoff Center for Families, Children, and the Courts at the University of Baltimore. I teach courses on family law and child welfare, and I've written extensively on family separation and its destructive impacts on low-income and minority families. I've represented hundreds of parents in child welfare proceedings, and I'm also the mother of 2 young children. I urge you to issue a favorable report on HB 1325. As you know, this law clarifies that there must be a nexus between marijuana use and any harm to the child. While a nexus between parental behavior and harm is always required under the law, marijuana use is currently treated differently. The stigma associated with drug use permeates the child welfare system, branding parents who use marijuana as unfit, even if they use marijuana safely, and there is no evidence of negative impacts on their children. As a result, parents, particularly low-income and minority parents, have their children unnecessarily removed, or in other cases, children who could be safely reunified with their parents remain in foster care because their parents test positive for marijuana. This is particularly problematic because marijuana, unlike other drugs, stays in your system for weeks. A parent whose child is at a sleepover or safely in the care of a relative or friend could use marijuana and test positive later when the child is actually in their care. A positive test is only evidence of use, not misuse, yet children are removed from their parents anyway. Removing a child from their parents is one of the most traumatic experiences that a child can have. Children suffer grief, anxiety, and post-traumatic stress disorders. One study showed that as a group, foster children experience twice the rates of PTSD as United States war veterans. When discussing family separation at the southern border, the president of the American Academy of Pediatrics explained that separation from one's parent can have permanent effects on a child's brain architecture. She said that separating children from their parents contradicts everything we know about what is best for children's welfare. Yet, in the name of child welfare, we separate children from their fit parents because we place moral judgment on them as drug users. Most often, this judgment falls on low income and parents of color, and their marijuana use allows the child welfare system to continue to surveil them and force them to live under constant threat of their children being taken away from them.
Scrivetti, please.
No problem. HB 1325 makes clear that marijuana use doesn't equate to unfitness and therefore prevents the detrimental impacts of unnecessary removal on children and the system as a whole. For these reasons, I urge you to support HB 1325, and I thank you for your time and consideration. I'm also happy to answer any questions.
Thank you. Stephanie Glaberson, please.
Thank you, Chairman, Vice Chair, and members for having me. I am a Maryland resident, voter, and parent. I'm also a visiting professor and director of the Civil Litigation Clinic at Georgetown Law, where I research and write on topics related to today's bill. I previously worked as an attorney in New York, representing more than 100 parents in child welfare proceedings, many of whom face marijuana-related allegations. I'm here today to urge this committee to issue a favorable report on HB 1325, as it is a necessary measure to begin to narrow the doors through which racism and bias enters into child welfare decisions. It is not news that the child welfare system disproportionately surveils and breaks up families of color and poor families. I have seen in my own practice and have heard from Maryland practitioners how marijuana allegations in particular disproportionately affect families of color. First, the evidence shows that Black and white populations use marijuana in equal numbers. Yet, for example, Black women are 10 times more likely to be reported for investigation as a result of prenatal drug use, even though the evidence shows that white women use substances at higher rates while pregnant. So families of color wind up facing allegations of marijuana use more frequently. And once those allegations are in a case, they often become the allegations that follow parents the longest. They become an entry point for racialized bias and shift focus from where it should be, on child safety. Even where marijuana use may not make up the core of an initial filing or the reason for removal, marijuana allegations often become a reason to deny visits, to refuse to expand visits, or deny reunification even when there are no other remaining safety concerns. In my experience, the system ends up insisting on total abstinence when we know, as Ms. Trivedi just mentioned, that a drug test is not a parenting test. It is possible to responsibly, therapeutically, or recreationally use marijuana and safely parent children. Given this context, HB 1325 really is the floor. It is no more than a clear statement of what the law already should require, that to intervene in a family, there must be a connection between any alleged parental conduct like drug use and a risk of harm to the child. But it is still a vital and necessary statement from this legislature. Especially as Maryland moves towards legalization, we need clear statements from this body that marijuana use alone without evidence of a risk of harm to a child is not sufficient as a basis for a finding of neglect. For these reasons, I respectfully ask that you issue a favorable report. Thank you.
Thank you. We'll go to questions now, and Delegate Anderson.
Yeah, thank you, Mr. Chair, and thank you for bringing this bill, Delegate. It was like one of the things that I guess you never really think of. My question first, I guess, is to any of the panelists. How does a person end up getting tested in the first place for marijuana use in these situations?
Thank you for that question, Delegate Anderson. I would say that in any case, if there's an allegation that's made against a parent, so for instance, in the case of my client, an allegation may have been made that she smokes marijuana, then the department then has the right to ask her to take a test. And
how did they get that right to force someone to take a test?
Well, they can bring that allegation to the court that they believe that the parent smokes marijuana, and then the court can order that the client take an assessment, which would generally include urinalysis. And if that assessment is positive, then usually within the orders of the court, it would say, a drug assessment and follow any and all recommendations.
Well, what is the burden of persuasion that the court uses before it orders that someone to take this this analysis?
Just the allegation that they are in fact using marijuana.
Just a bold allegation from anybody.
That is generally what it takes to something like that.
All right. My second question, Mr. Chairman, if I could, is in the bill, you're saying that neglect does not include the use of marijuana, unless as a result of the use of marijuana, the child's health or welfare is harmed. That's kind of a broad spectrum, health or welfare harmed, and who makes the determination as to whether it's harmed or what degree is it harmed? Anybody can answer that as well.
I mean, you've identified one of the major problems with child welfare law generally. The laws are very broad, and that's what the current neglect law says. This idea of mental injury, for example, the idea of harm, it's just that. And the court determines based on arguments from either side whether or not harm has occurred. And once the court has decided that a child is in need of assistance, they have broad authority to order anything.
Okay, so here's my addition, I guess, to this thing is that I agree with you 100% with what you just said, that once they decide the child is harmed, I don't think it matters how the child was harmed. You know, if they've come to that conclusion, then they go to the next step. So including these two categories, unless as a result, the child's welfare is harmed or the child suffered mental injury, I think you're opening up the gate to allow them just to continue to use marijuana use as an excuse or as a reason to perpetuate what we're trying not to perpetuate in this bill. Why not just say neglect does not include the use of marijuana, period? Obviously by a parent, individual who has permanent or temporary care, custody, or supervision of a child. I think that those two caveats, Roman numeral 1 and 2 under section 2, weaken the bill, and I think it probably would allow for social workers or whoever makes these decisions to go ahead and make decisions anyway. Especially when you consider the fact that of just the allegation. Oh, I think I saw her smoking marijuana, and so therefore the person gets tested because of that. So I think that the system encompasses too much already. I'd vote for this bill if you took those two things out. Well, I'll vote for it anyway, but.
No, I would definitely agree with you. And if this body would vote for this bill with taking those two things out, I definitely think that you should.
Ms. Trivedi?
Oh, I wholeheartedly agree. This bill just clarifies what sort of the existing law already says, that to prove neglect, you have to demonstrate a connection between the act or omission that causes harm, either physical harm or mental injury. So I think the bill's intent is to say, you can't just say a parent uses marijuana, which is what we see in child welfare generally. And just to add on to what Ms. Kalfani said before, even if a court does not order a marijuana test, what often happens is caseworkers say, we have an allegation that you use marijuana test. Will you voluntarily, just to clear this up, take a test? But if they don't, it then becomes an allegation and is enforced by court order, or it's used as some sort of evidence that the parent is hiding or otherwise unfit or as a liar.
And in a TPR proceeding, which can go on for years, whatever happened 4 years ago is still used against the person that day. I mean, these proceedings are sometimes interminable. That's why you get very few lawyers who want to take these things on. But once an allegation is in there, once a test is taken or not taken is in there, then the person's almost sunk. And I'm just saying, I think when you're talking about neglect, neglect does not include the use of marijuana, period. Anyway, that's my concern. No need to respond. I'll vote for your bill, but I hope that we could get these two out.
Thank you.
All right. We will hear now from Delegate Juanita Fisher, followed by Delegates Grammer and Erican. Delegate Juanita Fisher.
Thank you, Mr. Chair. I just have a clarifying question. Can you hear me? Okay, sorry. I just had a clarifying question. Thank you, Delegate Williams, for your hard work on this and many other bills that you bring to our committee. With the concept of like alcohol use and then just smoking and just nicotine, just cigarettes, how is their use, and those are obviously legal and regulated substances currently, how are they impacted in someone's child abuse cases, or, you know, like exposure to the child that's making it a dangerous situation. And would this bill, whatever that is, would this bill bring marijuana use into parity to someone who is, I guess, drinking excessively and exposing the child to alcohol? Or like, I don't know how chain smoking works, and like the child getting all that secondhand smoke from someone who chain smokes. Nicotine is dangerous to me, but I don't know how, if you could clarify how Child Protective Services views those two substances, and then how cannabis would compare in a legal state with those two.
I would say that there has to be, and there generally is, a direct connection between a parent's consumption of alcohol and an injury or neglect of the child. In those cases, one would not necessarily mean the other. So because of your drinking, your child ended up getting hurt some kind of way. You know, you hurt them, or you abuse them when you're drinking, or something of that sort is generally how that is used. I can say when it comes to cigarette smoke, that's generally, I've never seen a case come in because of a parent's cigarette smoke. I can say there are issues once a parent is in the system and they're being surveilled in the system, then they will often, the Department of Social Services will often use the fact that the parent smokes and they come, you know, to visit smelling like smoke as another barrier to prevent reunification. So in that way, it often happens, but I've never seen a petition actually come in because of something like cigarette smoke. And when it comes to alcohol, there's generally a direct connection between the two. Whereas marijuana, as you heard, there's generally no connection. It's just another reason that makes this parent unable to care for their child.
So if we pass the bill in this form, or the forms in which Delegate Anderson also suggested, then the only thing would be the person's already in the system and being monitored, and it would be they're coming in, they smell like weed. This just shows whatever irresponsibility or whatever the person's projecting. So it would just basically be on parallel as the smell of like nicotine or cigarette smoke in that situation.
Correct. And it would give us the opportunity to argue to say, this is not, you know, marijuana usage is not neglect, therefore it can't be a basis for a barrier to reunification as well. And I will say that we did submit the same bill to the Senate, and they are, we did amend the bill to specifically state that it cannot be a barrier to reunification as well.
Delegate Grammer, then Eric Hand.
Thank you, Mr. Chair, and thanks for the bill. Question for anyone or everyone on the panel. So let me back up a step here. When there is a neglect allegation in regard to drug use in general, can you tell me how this kind of manifests, how it's presented, how it's put forward as a means of challenging a person's custody? What's the argument that's typically made for drug use in general? Anybody could respond to that.
So allegations of drug use in general, one of the main ways that allegations for drug use come before the court is when there is prenatal use or substance exposure. So that is one of the ways that it comes in. In other ways, and my colleagues can definitely correct me if they disagree, but in other ways, it's generally, again, something that's added on. So if there is an allegation of neglect, whether it be that the home is dirty or, you know, the children are unkempt, they're consistently late for school, there could be any number of allegations, and then substance use will just be added on to that as another reason as to why the parent, again, is unwilling or unable to care for the child. There are some cases, and I would say these are the fewer cases where, again, there is some type of direct connection between a child being injured and a parent using drugs. Another way I would say it comes in is if there is a witness of someone using drugs or intoxicated in public, or under the influence, I should say, in public, and the report is made that way. So those are generally the ways in which these type of cases or cases involving drug abuse would come before the court.
Does anybody else want to add to that?
I would just say that I think what the bill is really doing is sort of clarifying a presumption that if you use marijuana, you are somehow causing harm to your child, and this presumption is not written into the law in any way, but it's just sort of the way that it's applied. And I think often the family has made great strides to rectify whatever the actual issue is that brought them into child welfare proceedings in the first place. And then right before the kids are supposed to go home, somebody says, you know what, there was either an allegation of drug use or there was no allegation, but we'd like you to take a drug test just before we send the kids home. And if the parent tests positive for marijuana, the kids do not go home, even if the parent has corrected every other issue that brought them into court in the first place, and even if there was never an allegation of drug use in the first place. And either it's by court order, or like I said, they're told it's voluntary. We just want to make sure everything's fine. And most often, those requests, and I use requests sort of facetiously, are made of low-income parents and parents of color.
So the reason I asked is because I've had experiences of these kind of cases in my district, not people I knew personally, but cases that I've been given the details. And it would be these types of things that I've experienced typically happen in a greater context, like, household is going sideways, addiction, and then we found out the child was being sexually abused by gentlemen who were selling drugs. So I'm almost inclined to agree with Delegate Anderson, not because the additional language opens the language up, but I think adding the additional language, might restrict a judge's ability to use this. I haven't seen many cases. I haven't seen any cases where these kinds of things have been adjudicated specifically for marijuana use. But wouldn't it be more appropriate just to say, marijuana use doesn't constitute neglect, and that way, if there was a bigger issue, there were signs of neglect elsewhere, all kind of different attributing factors. They could just say, well, okay, if they use marijuana, we're not going to use that exclusively as the determining factor here. I guess I'm agreeing with Delegate Anderson, maybe for a little bit different reason.
Is there a question or no?
No,
No.
isn't that so?
Oh,
Mr.
okay.
Chair?
Isn't that so? Thank you, Delegate Rammer. That is the purpose of the bill, is just to limit it solely, so that cannot be the sole basis, so.
Delegate Arakan.
Thank you, Mr. Chair. Thank you so much to Delegate Williams for being so brave to put this in. I have had people that I know who have had their babies taken from them at birth over this, when only they tested positive. And in fact, one woman had never used marijuana. She used CBD oil, and the hospital refused to run a THC panel. And she had to have her home inspected multiple times. This is nothing short of abuse of these poor women. So thanks for putting this bill in. I'm wondering a little bit about what Delegate Anderson had touched on. I know from my perspective, at least, for a parent to make the choice to use marijuana is different than, for example, if I had dropped my child off to a nanny who I did not wish to use marijuana. So I'm just wondering, how would this play out? How would that scenario play out? Does this bill address that concern, or could we potentially have not just a parent, but like a third party who maybe the parent had specifically said, please do not use marijuana with my child, then they do, and my child's injured. What kind of impact could this bill have?
I think it would serve in the same way in terms of protecting the parent. In that situation, the department would have to find that the parent somehow contributed to the harm that was in the other person's care. So I think the fact that it specifies that it's not used by the parent, that is a protective measure in that situation, but there would have to be some connection between something the parent did that contributed to the child being injured in the other person's care in the baby's care.
Okay, that makes sense. And then can you just refresh me again, what was the language change that happened on the Senate side? And Delegate Williams, if you're amenable to that change or not, once we hear what it is.
I would have to send the exact language to Delegate Williams, but it just stated that a parent's marijuana use could not bar reunification.
Okay, yeah, that might be a great additional piece to put in, and hopefully we'll move favorable on this and protect some of these women who are losing their kids to this.
Thank you.
Thanks.
I'll just add that the Senate cases are for parents only. The criminal neglect statute would apply for other caregivers, like in your hypothetical.
Are there further questions for the panel? Seeing none, we thank you all very much for your testimony. And now we'll go to the one person testifying in opposition, and that is Vince McAvoy. We'll hear from him for 2 minutes. So let's see if we can get Mr. McAvoy in, please.
All right, thank you, committee. Am I on?
Yes, go ahead.
I am on?
Yes, go ahead.
Can you hear me?
Yes.
Thank
Go
you.
ahead.
I've got a bad internet connection here. Thank you for taking this testimony. I'm having a bad internet connection. 1 Corinthians 10, all things are lawful to me, but all things are not expedient. All things are lawful, but not all things edify. Weed isn't even legal. Advocating legal use is by itself bad parenting. DC has this for the neglect clause. Neglect the child means the following: child is born addicted or dependent on a controlled substance. Where do you get this? How do you get there? It's through these type of substances. You can't parent on drugs. When I hear people promoting a lowest bar, this lowest bar of parenting, they're not parenting, they're biological babysitters. Where to Delegate Anderson was harmed. They're not looking for a way to involve marijuana somehow with the parent who they're investigating. How do I know? Because when I worked down at Siena, we had parents come into my office and dose up with opiates. 5-year-old poor darling girl in tow, while her mom's dosed up in my office. Siena has a family recovery program which is given to its women, almost entirely women, regarding child custody or other restrictions for DSS. They get 3 strikes, and they can't even make that. I can't tell you how many case files we had that we had to just throw away and rip up because they don't finish the program. Baltimore City has the broadest scope and number of cases: addiction, mental illness, lead to cases which I've read, child care, children walking in 2-day-old diapers, dog feces dried on the floor. These are the type of things that you need to look at when you're looking at a bill like this. I urge you not to pass this. The harm becomes to children, letting them eat paint, letting them run off attended, leaving them in cars. How many deaths of children being left in cars? How do you forget your child? This is your answer. Inhaling whatever the drugs are being smoked. I went by 2 women driving a few months back, car entirely filled with smoke. A boy in the back with a school iPad, and a younger daughter sitting in the car seat next to him in the back seat. I urge you unfavorable on this. There's no reason to etch this out. They are already looking at these cases. Thank you.
Thank you. Questions for the witness? Seeing none, we thank you very much. And that concludes the testimony for House Bill 1325. We're going to go now to House Bill 1269 and Delegate Shoemaker. This is Delegate Shoemaker and Sheriff DeWeese from Carroll County. So Delegate Shoemaker, for 3 minutes, go right ahead.
Thank you, Mr. Chairman. House Bill 1269 arises out of a situation, a tragic situation that made the news in my county over the last year. I'll talk more about that in a second. But essentially what this bill does is it requires volunteers that work with children to submit a criminal history records check and a child abuse and neglect clearance. It requires the Department of Public Safety and Correctional Services to maintain those records. And it creates a database of information about volunteers who work with children to be maintained by that department. Now, this bill that's before us is modeled after legislation that passed in Pennsylvania. I can tell you that as of January of 2021, the states of Alabama, California, Florida, Massachusetts, Mississippi, Nevada, New Hampshire, Oklahoma, Oregon, and Pennsylvania have enacted similar background check requirements for volunteers of non-school associated activities of youth sports. With regard to the situation that gave impetus for this bill, a few months back, a man from Parkville in Baltimore County who had bounced from program to program in the Baltimore County rec sports arena and had been subsequently banned from participation in those programs because of, I guess, strange behavior, offensive behavior. Well, he was able to come over into Carroll County and he volunteered as a football coach with a recreational sports or recreational football program in Carroll County, where he sexually molested a young man over a period of time. After he left that recreational sports program, he subsequently became a coach, a JV coach at a local high school in my county, and continued his inappropriate behavior with that same individual who had gone from youth sports to the high school. I've met with that young man, and I can tell you that he will bear the scars mentally and physically from the trauma he suffered at the hands of this individual, this predator, probably for the rest of his life. So if this type of volunteer clearance program that I'm proposing will prevent one person from being victimized like that young man was, who's my constituent, then it'll be well worth the effort. So with that, Mr. Chairman, I would turn it over to Sheriff DeWeese.
Sheriff DeWeese, go ahead for 2 minutes.
Thank you, Mr. Chairman. Do you hear me okay?
Yes.
Okay, thank you, Mr. Chairman, members of the House Judiciary Committee. I'm Carroll County Sheriff Jim DeWeese. Thank you for allowing me the opportunity to speak favorably regarding House Bill 1269 volunteer clearance. In support of HB 1269, I feel strongly that individuals volunteering to work with our children in youth athletics and our recreational councils, private organizations, and schools should be vetted properly and thoroughly before receiving a clearance to start coaching or assisting. In 2021, my office received a complaint from an adult survivor of sexual abuse by a volunteer football coach that started when he was a freshman at a Carroll County High School as a member of the high school football team. Our victim described over 200 sexual encounters between the age of 15 and 18 years old. During our investigation, we learned that our suspect was a volunteer coach or assistant in several public and private school systems and recreational council leagues in 2 Maryland counties and in Pennsylvania. Between 2007 and 2017, he volunteered at 9 different youth organizations or schools. We learned that many of the organizations asked him to leave because he was engaging in inappropriate behavior with children on social media and trying to meet with them before and after sporting events. Throughout our victim's high school life, he had an ongoing sexual relationship with this assistant coach, with encounters happening before and after school and sporting events and on and off of school property. Please understand that all of these organizations, I have no doubt, followed protocols by having this individual fingerprinted and cleared through CJIS before working with the children. But CJIS would only reveal an arrest, not a dismissal from an organization. Knowing what organizations made requests from CJIS throughout his volunteer coaching career would make it easier for another organization to pick up the phone and gain a reference before having them work with our children. A database that allows organizations to track a coach or volunteer may have stopped this abuse. And for these reasons, I'm asking for a favorable report by your committee on HB 1269. Thank you, sir.
Thank you. Are there questions for the panel? Questions for the panel? Seeing none, we thank you both very much for your time, and that concludes the testimony on House Bill 1269. Thank you very much. Oh, wait, I have a question. Delegate Cox.
Thank you, Mr. Chair. I was, I guess, late with the hand going up. Real quick, I appreciate you, Delegate, bringing a bill to protect our children. Was reading through it quickly, so I didn't have a chance to study it in depth. Didn't know about the bill ahead of time. So does this apply to churches with their ministries of volunteers like day camps and such? And also, what about private homeschool co-op organizations where you have a lot of volunteer parents that help teach in those settings? Are they going to have to go through this criminal background check? I noticed it's not just a abuse background check. It also says criminal records.
That's right. That's right. I believe, Delegate Cox, as the bill is written, it would not apply to those situations that, to those scenarios, those folks encompassed in the question that you posed. This is getting at youth sports organizations in particular, because as the sheriff alluded to, and as I talked about in my testimony, that's become a particularly problematic area. So, I mean, that's the crux of what the bill is directed at, not at churches.
Okay, and then a follow-up real quick. This database aspect is all new to me. It looks like it's new to the system. Is there a current database that exists right now for non-volunteer employees? Because this just says volunteers.
Yeah. I don't believe there is, although I can tell you that there are a number of states that have such databases. I think I alluded to the ones who have enacted like volunteer clearance bills or laws and have them on their books. So I don't think it would be terribly difficult to replicate.
Okay. All right. Thanks so much. Thank you. Good to see you, Sheriff.
You too, Delegate Cox. Thank you.
Delegate Cardin.
Thank you, Mr. Chair. Just very quickly, Delegate Shoemaker, if I am volunteering for my daughter's soccer league at Sacred Heart soccer program, would I be required to go through these rigmaroles?
If you, perhaps, I can delve into that a little bit with you offline, perhaps, but if you're regularly engaged in volunteering and activities that involve children, you may in fact be subject to it.
Okay. And even if I'm, for one season, I am the team's manager, I would have to go through all this. Okay. All right. Thanks.
Further questions for the panel? Seeing none, we thank you very much.
Thank you, Mr. Chair.
All right, and that concludes the testimony on House Bill 1269. We'll go now to House Bill 1319. Delegate Arakan. I'm going to hear from her, and there's a person testifying in opposition. So we'll hear from her for 3 minutes, please.
Thank you, Mr. Chairman. Thanks to my colleagues of the Judiciary Committee, Lauren Arkin for the record, District 7. This is a very simple bill that was brought to me by a constituent. She would have loved to be here to testify today, but she would like to protect the privacy of her family. And so she is not going to be attending in person, but I would like to share with you some of her words and just a few excerpts. I know we're short on time, so I'll just share with you a little bit about why she's asking for this bill. She writes, "Honorable delegates, I'm submitting my testimony anonymously to protect my family's privacy. I'm a cisgender, heterosexual female who's currently in the process of divorcing my spouse, who is transitioning from male to female. When my spouse announced the beginning of the transition process, I felt this was bigger than I could handle alone and needed a safe space to process. I sought therapy to maintain confidentiality, as I did not wish to discuss private matters with my friends and family. One common request of the LGBTQIA+ community is not to share the details of transition without the consent of the individual who is transitioning. The transition isolated me from my only support system. The trans community very much welcomed my spouse with open arms, positive affirmations, and in less than 6 months, a new friendship group was very much more important than all the previous associations. I was feeling less and less safe in our marital home. My hope was to support my spouse through the transition while still respecting my own physical and mental health. As my health deteriorated, I sought care from a medical doctor. I asked the committee to think about the consequences of me having to assert something like domestic violence as my reason for divorce. My spouse would have had to carry a stigma the rest of their life. If the cause of the gender transition, I have control over my life and I'm able to offer the person going through a very difficult transition more dignity. But I feel I deserve basic legal protections and a dignified path for divorce. As you all may know, there are grounds for divorce that are limited and absolute. Limited are separation, cruelty, excessive vicious conduct, and desertion. And for absolute, mutual consent, adultery, imprisonment for crime, or insanity. In her situation, none of those really fit. And so the judge did not grant her the absolute divorce, and she was forced to wait the period of time because her spouse was contesting the divorce, and unfortunately ended up having to move out of state and start a new life. So I'm here asking on her behalf and other men and women of spouses that we include something in the statute that allows a more dignified exit from a marriage. I'm not sure that most people can imagine being in such a situation, and I'm sure it's very complex. And this woman clearly tried very hard to support her spouse for many months through the process, but it just became too much. And I believe I've submitted her full testimony to you, and you're welcome to read through what her experience was. But I would ask for a favorable report on this bill. Thank you.
Thank you. We'll take questions now. The Vice Chair.
Thank you, Mr. Chair. This is a real simple question. Wouldn't it just be easier to just let people divorce?
That's a different bill for a different day, my friend. Yeah, that maybe. I mean, I did vote for the Chair Atterbury's bill last year to shorten it to 6 months. So that is great.
Did we pass that?
We did.
So I actually don't know what the rule is then that your bill is getting around.
So the problem was there was no mutual consent. So when she asked her spouse for the divorce, they refused. And so she couldn't go for a mutual consent. And therefore, in this contested situation, the judge ordered that they wait, establish separate abodes and wait 12 months and that kind of thing. So under
this is what I'm trying to get at. So under current law, if I'm trying to get divorced and my spouse doesn't want it, what's the quickest I can force them to be divorced with me?
6 months, and you can move into the basement under Chair Atterbury's bill that we passed last year.
Yeah. Okay. Thank you.
Further questions for the panel? For the delegate, I should have said. All right. Thank you very much. We'll hear from one person signed up in opposition. CP Hoffman, please. CP Hoffman for 2 minutes. CP Hoffman.
Thank you. CP Hoffman, I'm the legal director at I'm the policy director now at Free State Justice, which is Maryland's LGBTQ advocacy organization. Thank you for hearing me today. I find this bill to be wholly unnecessary. Maryland law allows for no-fault divorce with a relatively short waiting period. And if the issue is that that waiting period is too long, then the solution is to change that waiting period, not to create a new grounds of divorce that applies only to people based on sexual or only based on gender identity. It's striking to me that we do not have other exceptions for things like gays or lesbians coming out as gay or lesbian, which are situations where relationships are even more likely to be unsustainable in the long run. We don't have exceptions for religious conversion. Someone could join a cult and their partner would still need to wait the 6-month waiting period unless they can reach an agreement with their spouse on all terms. I frankly just don't see the need for this and think that writing an exception into Maryland law for gender identity or gender transition is highly discriminatory. Thank you.
Other questions? Right, seeing none, Delegate Shetty.
Thank you. Sorry, it took me a second to find the raise hand. Hello, CP. It is good to see you. I just have a question. I was reading through your testimony submitted to the committee file. Thank you for that. I found it particularly interesting to see kind of how this bill would compare in terms of where it puts it in line with other grounds for divorce. Can you elaborate a little bit on the grounds for divorce and what happens with this bill in relationship to that and other waiting periods that would be similarly situated?
Yeah, so for Maryland law, for the most part, requires a waiting period for most grounds of divorce. The exceptions are adultery, cruelty, or abuse. I forget the exact language used on the abuse provision. I don't have it directly in front of me, but it's basically, physical abuse. So this would be by creating, and then there's also an exception if you can agree on all terms. So this by creating a new grounds that allows for an immediate filing for divorce without having agreed on all terms would place gender transition on the same ground as adultery, as cruelty, as abuse. It would be essentially saying that gender transition is something absolutely horrific in the context of a marriage.
Thank you so much.
Delegate Eric Hand, then Delegate Cox.
Thank you for being here, CP. Do you think mutual consent is horrific?
No, but mutual consent.
No, that was it. That was my only question. Thank you.
May I?
Okay. Oh. I'm going to let CP finish her answer.
Thank you. Mutual consent is a specific exception to the general provisions. And when it was originally adopted about 7 years ago, it was with the specific intent that it be there, that the waiting period be kept in other provisions in order to encourage parties to reach an agreement and to keep the long, contentious divorce cases out of court to the extent possible by encouraging parties to come to the table and reach an agreement. So there is no waiting period for mutual consent, but it is not in the same category as the other grounds that allow for immediate divorce.
Okay, so is it the position of Free State Justice that if a party who is gender transitioning refuses divorce for their partner, that partner's needs and wishes should be completely ignored?
It is the position of Free State Justice that in the case of a partner transitioning, that there is not a need for a new rule in the divorce law beyond what applies to everyone else in other situations.
So the people should be forced to remain in a marriage for 6 to 12 more months simply because they don't feel comfortable or safe in their marital home anymore after gender transition.
You're not required to stay in the marital home. You're not required to do anything. It's just there's a 6-month waiting period before you're able to file for divorce.
Thank you, Mr. Chair.
Delegate Cox.
Thank you, Mr. Chair. Delegate Eric Can, from the story that I heard you discussing, it sounded like there's
And
certainly
just to be
a
clear,
measure of,
the question's going to CP Hoffman, right? Because we're on the opposition panel.
oh, I missed my chance at Delegate Eric Can. Okay, well then I will.
A long interrogation of Delegate Erican, yes. If you have a question.
I will direct this to CP then.
Fine.
So I heard Delegate Erican talking about the pain that her constituent felt that she was going through. One of the grounds of absolute divorce is constructive desertion, which is a fundamental change of the contract of the parties. Whereas it's similar to an element of cruelty where one party is denying the other party everything that they had signed up for, to put it in that context. Isn't this just a clarification of the law that constructively the party who has decided to fundamentally change from the original marriage is constructively deserting that marriage? Isn't that true?
No, it's not, in fact, because desertion has a waiting period.
Well, I'm not talking about desertion. I'm talking about constructive desertion related to cruelty. So in other words, if you deny, if a party constructively deserts and denies the other party, that's a grounds for absolute divorce. You're saying straight up desertion has a waiting period. I have to go pull the statute again, but I know that cruelty does not.
Yeah, cruelty does not.
Desertion is part of cruelty. So that would be my concern. I mean, this is a fundamental change. So
if one is able to make that argument now, then they're able to make that argument now, and they don't need this bill.
But wouldn't this clarify that? Apparently, from what we heard, it could use some clarity. In this day and age, everything is changing, and possibly it would be helpful. But anyway, thank you, Mr. Chair. Nothing further.
Are there further questions? All right. Seeing none, we thank you very much. And that concludes the testimony on House Bill 1319. Going now to House Bill 1374. There's Delegate Osvero. We'll hear from Delegate Osvero for 3 minutes, followed by Anissa Khan, Nathaniel Erb, and then there's a panel in opposition. So Delegate Osvero for 3 minutes. Everybody else for 2. Go right ahead.
Thank you, Mr. Chair. For the record, Delegate Gabriel Acevera here to present House Bill 1374, the custodial interrogation of minors, admissibility of statements. Our state's criminal laws are designed to ensure that juveniles accused of crimes deserve and should be afforded certain protections beyond those protections afforded to adults. House Bill 1374 extends this principle by creating a rebuttal presumption that a statement made by a minor during a custodial interrogation is involuntary and is inadmissible in a juvenile or criminal proceeding where the law enforcement officer uses knowingly false information to elicit the information. By design, the juvenile justice system is premised on the idea that juvenile offenders need protection, not just punishment. As a result, the juvenile justice system is decidedly less punitive, and the consequences of being found delinquent are far less severe than the consequences of a conviction in adult court. Current law allows police in most instances to lie about evidence during an interrogation to pressure the accused into confessing to a crime. However, false confessions are a leading cause of wrongful convictions in the United States. I will point to a more prominent case that folks may be aware of with the Exonerated Five, or formerly known as Central Park Five, where we see in this instance that It not only led to the false incarceration of juveniles, but really trauma and a community impact as well. Young people are especially vulnerable to deceptive police tactics that aim to convince a person that denials are pointless and confessing is the only option. Indeed, the parts of adolescent brain responsible for future planning, judgment, and decision-making are not fully developed until a person reaches their mid-20s. Consider a report prepared by the National Registry of Exoneration. It reveals that of the 211 exonerees who are wrongfully convicted as children, 36% falsely confessed, whereas only 10% of the exonerees who were wrongfully convicted above the age of 18 falsely confessed. As the infamous case of the exonerated 5 that I talked about earlier demonstrates, one need not look too far to understand the consequences of false confessions secured by deceptive police interrogation tactics. We should join our colleagues in other states such as Illinois and more recently Oregon in curbing the use of deceptive police tactics in the interrogation of juveniles by creating a rebuttal presumption that evidence secured using such tactics is involuntary and inadmissible. Accordingly, I urge a favorable report on House Bill 1374. Thank you, Mr. Chair.
All right, thank you very much. We'll hear now from Anissa Khan, please, for 2 minutes. All right, they are not here, so we'll go to Nathaniel Erb for 2 minutes. Go ahead for 2 minutes.
Thank you, Mr. Chairman, members of the committee. My name is Nathaniel Erb, resident of District 2A, here on behalf of the Innocence Project in support of House Bill 1374. This bill mirrors legislation that we passed in Illinois, Oregon, and Utah, which we worked with statewide prosecutors, law enforcement, and other associations. HB 1374 narrowly prevents intentionally lying about evidence or leniency that could be provided to a child in order to coerce a confession, which, while still allowing potential introduction of the statements into court if a rebuttal presumption is overcome. The International Associations of Chiefs of Police and interrogation experts from DOJ's High Value Detainee Group and other national law enforcement groups and experts all recommend that police do not use deceptive tactics against children, noting that they not only risk false confessions, but are unnecessary in the light of more reliable methods. Even Reed and Associates, the purveyors of the Reed method, now caution against deception's use against juveniles. We see throughout false confessions and wrongful convictions that existing procedural remedies that test voluntariness are not sufficient to prevent false confessions elicited through deception. In short, what interrogators have deemed unsuitable for terrorists, we should not be using against our children. I want to thank the delegate for sponsoring this bill. We respectfully urge a favorable report.
All right. Are there questions for the panel? Questions for the panel? All right, seeing none, we thank you both very much for your testimony. And now we'll go to the testimony in opposition for 2 minutes, looking for Edward Coyne. Edward Coyne. Edward Coyne. All right, he's coming in now. We just need a moment. All right, Mr. Coyne, you have 2 minutes, please.
Good morning, Mr. Chairman and members of the committee. My name is Edward Coyne. I'm the Deputy State's Attorney for Carroll County. I'm testifying in opposition of House Bill 1374 on behalf of the Carroll County State's Attorney's Office and the Maryland State's Attorneys Association. House Bill 1374 is an unnecessary hurdle for the police in obtaining statements from suspects, including those of juvenile, and is already covered. The protections are already covered under an existing law. In Maryland, when the state introduces a statement of a suspect, including those juveniles, we have to get over 3 hurdles. We have to get over Miranda, which are the rights read to the suspects that are in custodial confinement, which gives them all the rights. We have to get over common law voluntariness, which prevents improper promises, inducements, coercions, threats, and arguably deception. And then we have to get over the constitutional level of voluntariness with a preponderance of evidence. And those types of things include the age of the offender, intellectual disability of the offender, educational background, and other customized, they're custom to the juvenile. There's a whole list of factors that the courts must consider to introduce a statement. And then even after the statement's introduced at a trial, The jury is instructed beyond a reasonable doubt, they have to find it voluntary. So all of these things would be covered, which is even a higher hurdle than the current law to make this law unnecessary. And I would suggest that there's case law that suggests that it might be shocking, but sometimes people that are accused of illegal acts are not forthright right away. And under some circumstances, it is an acceptable use, as again, even the Reed method cautions. I think the other sponsor or other witnesses have testified that Reed method cautions, but sometimes deception is a valid tool in the toolbook or for the law enforcement to use to confront suspects, such as, hey, we saw you on video. What do you have to say about that? To get them talking, because again, they might be reluctant to admit their involvement or provide information about a particular crime. So I would join the Maryland State Attorney Association in opposing House Bill 1374 as an unnecessary hurdle for law enforcement to get to the truth of justice, and as already being covered under the existing law, especially when most statements are videotaped, where a fact finder, unlike in New York years ago for the subway cases, most statements are being recorded so it can be evaluated appropriately under the current law. Thank you, Mr. Chairman.
We're going to go now to Delegate Carden for a question. Delegate Carden.
Mr. Chairman, Mr. Coyne, am I understanding your testimony? You said at the end of your testimony that deception at times can be appropriate and it can be a good tool for us, or it should be a tool in our toolbox. I think that's what you said.
I didn't say that, Your Honor. Delegate, I said it can be an acceptable tool or a valid tool that's open to the police to confront suspects. It's not a favorite tool, as even the other members that have testified said. The Reed method, which a lot of different law enforcement officers are trained under, the method of interrogation, it's not necessarily the first tool you go to. Usually it's good to get people talking, but again, the Maryland Court of Appeals in Ball versus State said it is an acceptable tool in the tool belt of law enforcement, because sometimes they do have to confront witnesses if you go too far. And that's where, again, the law already has existing tests for this. If you go too far and create false, like say you create a false DNA test or scientific documents, we found your DNA and here's the DNA results, that might be considered too far. But if you tell someone, hey, way of information that you were at the scene of this crime, whether they do or they don't, or it's triple layers, so-and-so said they were there, how reliable it is, they can confront them. Again, it's a depends. And this would be a bright line test to keep all statements obtained by any deception pretty much out of evidence, likely out of evidence, where under existing law, you have to overcome the 3 levels of tests before a statement's admitted to evidence, and a jury beyond a reasonable doubt, or a judge, if it's a bench trial, have to find beyond a reasonable doubt that it's voluntary. No improper inducements, threats, those kinds of things, or deception.
Thank you very much. And I'll just comment that in the beginning of your testimony, you said it is an unnecessary hurdle and it's already included in the law. Those, to me, are dichotomous and probably shouldn't be used in the same testimony. But now I think I understand your comments that they are already included if you, to a certain degree, and this would just make it even more difficult to use deception. I think that's the way I understand it. So I got you. Thank you.
Thank you. Sorry for the confusion.
Delegate Bartlett, then Delegate Crutchfield.
Hi, thank you, Mr. Chair. My question is for Mr. Cohn. While I understand that the law says that deception may be used in interrogation, as a matter of public policy for children, because some defendants can be as young as, what, 14 years old, 15, 16? What's the youngest?
There's no, I think the age of infancy is 10 in Maryland. I think there's bills this session that may address some of those issues, but it depends. And they interrogate younger kids different than older kids, because as I told you, one of the hurdles is Miranda, and a 10-year-old is unlikely to understand Miranda. You have the right to a lawyer. They might not even know what a lawyer is. So it's difficult to conduct a custodial interrogation on a younger person. So this law might not apply to those kids anyway, because you're likely not to conduct a custodial interrogation on a child that young. So I agree that there are some significant hurdles to get a voluntary custodial statement from younger kids, because you wouldn't get over one of the first tests, which would be the Miranda warnings.
Well, I appreciate you saying that in view of another bill that's sitting out there, but with respect to the Miranda warnings. But as a matter of policy, doesn't it seem somewhat unfair to lie or to deceive children when there are other methods that are available in the toolbox for law enforcement?
I agreed, and I think it's been said before about the Reed method doesn't encourage it, but I would suggest that this is a bright line rule, so you're taking away that tool pretty much from law enforcement. The way this is written, it would pretty much take away that tool with that clear and convincing requirement. So that's a significant hurdle. And I would suggest that Lee Boyd Malvo was a juvenile when he, without provocation, killed multiple people. He was 17. And so if the police had to interrogate him, he's accused of a major crime. And if he didn't want to make a statement or he's lying to them and they have to confront him, we saw you on video, and then that spurs him to make a statement. I would just in balance, when you look at all the other factors, his age, his intelligence, any experiences, any mental illness, the judges already consider all those other things under existing law, that if the police went too far, they could, the court or a jury could not consider that statement if necessary, if it was unfair. So I would suggest on public policy, it depends. Every case is different. Every suspect is different. Some 25-year-olds have significant cognitive abilities. I prosecuted someone who was had a 69 IQ, and that he made a statement in which I believe was a false statement. It wasn't because of age, it was because of his cognitive limitations. So I would suggest every case is customized and different. And these bright line rules, I would suggest take away a tool unnecessarily because you already have existing law that already covers it.
Well, but there's also the availability for other evidence that should be used. I mean, because isn't that the principle that our forefathers came up with, that the government, the state should, or the government, because it could be federal, should present evidence against a defendant or against someone who was accused? Wasn't that the entire thought process, that it is part of the government's job to investigate and get evidence and present that evidence?
I agree, Delegate, that it is the government's job to collect evidence, and part of the evidence are statements from suspects, witnesses, and victims. So I would suggest it's all of it. And in the end, we want truth and justice. Truth being we want reliable evidence, and a confession is a reliable evidence if it's in compliance with existing law. So I would suggest, why would we give up evidence? Because in some cases, without the statements of the suspects, there's not enough evidence to solve a case. So many cases.
You know what the law says: when there's not enough evidence to solve a case, then the case gets dismissed. Isn't that so?
No, that's not the case. If you have evidence from a suspect, from an accused or a witness, whatever, that can be evaluated by a fact finder. So I would think that most of the citizens that want public safety and want justice would want all the evidence, so the fact finder, a judge, or a jury can evaluate the evidence on credibility grounds. I don't know why we'd have one arm behind our back when we're trying to solve a case. And when you completely preclude or make it such that we can't access certain information, that you're only getting part of the story rather than the whole story. So I would suggest for truth and justice.
Sort of like the position that the child defendant would be in, that they're getting part of the information and not all of the information because the law enforcement is allowed to be deceptive.
I would suggest that when you're interviewing somebody, you're normally trying to receive evidence, not give evidence. So I would suggest most of the time officers, if they're doing it in a good way, are trying to ask open-ended questions to get the suspect talking. That if you have the person use their own words, it's less likely to be a false confession, or you're doing suggestiveness, which is already covered under existing law. This law wouldn't add any, I suggest this law wouldn't add anything that's already there. It would simply take away a tool for law enforcement in those cases where deception may be necessary to get the person to go beyond their initial denials.
I understand your point. And I just guess that what is difficult for me to understand is whether deception should be allowed. But that's another conversation for another day. Isn't that so? Thank you very much.
Thank you, Delkit. I appreciate it.
Prodigious use of "isn't that so?" Are there further questions for the witness? Seeing none, we thank you very much for testifying today, and that concludes the testimony for House Bill 1374. Going now to the first of two bills from Delegate McComas. This first one is a 2 and a 1. It's a reintroduction. This is House Bill 1169. We'll hear from Delegate McComas for 2 minutes, and then Darlene McLaughlin, who will testify for 1 minute. So here we go. Delegate McComas for 2 minutes, please.
Thank you, Mr. Chair. Ms. McLaughlin put the stuff in the system, so she won't be testifying. So can I get 3 minutes? Just asking. I'm being funny. Okay.
No.
We've heard this bill. Hey, give me credit for trying. My goodness. This bill has been heard twice before and passed out of our committee and out of the House, and then it meets that wonderful brick wall of the Senate. But anyway. This requires the Maryland Department of Health to provide each health occupations board that is authorized under current law to take action against an applicant, licensee, certificate holder, registrant, or permit holder who knowingly fails to report suspected child abuse as required by current law, with a list of generally recommended courses on the obligation to report abuse and neglect, and the identification of abused and neglected children. Each board must post the information required for a prospective student to enroll for one or more of the recommended courses prominently on the board's website. 2, to provide license renewal information about the courses to specified healthcare professionals at a time of license renewal. Or 3, advertise the availability of the recommended courses in the newsletters and any other media published by the board. These provisions do not apply to a board that requires licensees, certificate holders, registrants, or permit holders to obtain CLEs, continuing legal education, on the identification and reporting of abused and neglected children. Child abuse experts know firsthand the impact that such abuse of our children has on society as a whole. More importantly, they understand how imperative it is to have appropriate training to improve the outcomes for child victims. Training for mandated reporters to recognize the abuse and then how to report what is observed is the next best step in protecting our most valuable asset, our children. Please enter a favorable report for HB 1169. They say the third time is the charm. Attached to my testimony is the HB 600 third reading out of the House, which had 135 yeas and 1 nay and 2 not voting and 3 absent. And then the 2019 HB 1252, 37 yeas, 3 not voting and 1 absent. So you can review that. But anyway, we've been here before. It's a good bill, and certainly with the ACEs and the educational push about the adverse childhood experiences and everything that we've learned through our committee, as well as HGO and some of the other committees, about the long-term and probably permanent scars that child abuse and neglect have on kids. This is a good bill, so I hope you consider it. Thank you.
All right. Are there questions for Delegate McComas? Any questions? Seeing none, we thank you very much. We'll go to House Bill 1246. Now, also from Delegate McComas. We'll hear from Delegate McComas and Ben Bell. We'll hear from both of them. And let's start with Delegate McComas, who gets the full 3 minutes this time.
Oh boy. Okay. This is HB 1246, Child Abuse and Neglect Reports and Records Disclosure, Anderson's Law. This is a very simple bill that clarifies Maryland's obligations under federal law to release to the public Department of Health records when a child who has a history with the department suffers a fatality or a serious near fatality injury. Under the Federal Child Abuse Prevention and Treatment Act, called CAPTA, every state is required to ensure that the public is informed about cases of child abuse or neglect that result in the death or near death of a child. The state must make public the child's age and gender, the cause of the fatality or near fatality, information describing any prior reports of child abuse or neglect involving the family, information regarding investigations pertinent to the child abuse or neglect that led to the child's death or injury, and services provided and actions of the state on behalf of the child. The problem with the current Maryland law is that while it provides for the release of this information, it has an exception that swallows the entire rule. Under the current law, the state's attorney can block the release of this required information. merely by stating that the release of the information would harm any related investigation or prosecution. Of course, there will always be an investigation into child abuse related fatality, and the presence of an investigation should not allow the agency to avoid its legal duty to the public. So what this does is there's an amendment that's been made, and we sent out the amendment by email to you all. And basically what it does is it says in the purpose paragraph, it got amended. So there's deletion, and then what it basically says is the state's attorney's office is allowed 10 business days after the consultation to redact from the record to be released any portion of the record that, if made public, would seriously hinder the investigation, the ability of the state's attorney to prosecute a criminal case arising from the incident. And it deletes on page 2 from line 17 down to the bottom, and just puts that in. And so that it's a nice fix. It protects the integrity of the state's attorney's investigation, but it does allow for the information to be disclosed to the public. And in a sense, it kind of lines up with Delegate Valentino Smith's bill as well that you heard today, the first bill. So with that, I turn my, if there's any questions, I'll be glad to answer them, but I'll have my witness testify next.
Let's hear Ben Bell testify now, please. Mr. Bell, for 2 minutes.
Good afternoon, honorable members of the Judiciary Committee. My name is Benjamin Bell. I previously worked in the General Assembly, and I'm a licensed social worker. I also briefly worked for DHS in Maryland. I want to emphasize that this is a very collaborative and bipartisan bill. It is also a very serious bill with very serious consequences. We have worked closely with the department and this committee and have already amended the bill to show in good faith our desire to have this passed. By passing this bill, the state will increase transparency to its constituents and put the state in compliance with federal law CAPTA. We are here to answer any questions, comments, or concerns you might have about this bill. Thank you for your consideration.
Are there any questions for Delegate McComas or the panel? Seeing none, we thank you both very much. And that concludes the testimony for House Bill 1246. That concludes the testimony for our bills today here in the Judiciary Committee. As I announced, it was going to be either 30 minutes after the bill hearings or 4 o'clock, whichever was later. So we'll see you at 4 o'clock. Try not to have too much fun in the next hour and a half, but we'll have a voting session at 4 p.m. Today. And the vote list has been printed and provided. So thank you all very much, and we'll see you back here at 4.